So the protection of gay rights and LGBTQ activity is an interesting one because there are really two facets of this, and I want to make clear what it is we're talking about in this section. We are not talking about governmental discrimination against LGBTQ individuals. So we're not talking about laws that treat um, individuals who are LGBTQ differently than others. What we're talking about is the privacy aspects of this. And the privacy aspects deal with the ability to engage in sexual behavior, uh, and also, to some extent, as we'll get at the end of this section, the decision and choice to marry. This isn't about discrimination, which is also, and I think, a very large part of gay rights that I'm completely missing. But I do that because this section of four cases fits very much more succinctly within the realms of privacy than it does anywhere else. And the way that we'll see that is through the regulation of sodomy and sodomy laws that have existed or did exist in the United States. So there are two issues here that the courts have had had difficulty dealing with. It's pretty clear that there exists a significant amount of privacy in an individual's home. We learned that from Stanley v. Georgia, that there exists a boatload of privacy in an individual's home. And in fact, Griswold tells us as much when we hear about, would we allow the police to search the sacred precincts of our marital bedrooms for the telltale sign of contraceptives? Well, you only have to change a couple of words to that and you get directly to homosexual behavior. And it seems that Griswold would be guiding in this case as well. So looking at Stanley and Griswold, one would think that such laws, like sodomy laws, had been difficult for courts to get access to. And the action was fairly difficult for courts to get action to. But there's also an equal protection element going on here. And that is, some states had sodomy laws on the books that only applied to same-sex individuals. Now, that's an equal protection question. And that question is much more strenuous to get to, but the actual outcome of that is a little easier. You have a law that treats differently situated individuals differently, which is to say that individuals can engage in the act of sodomy and be, differently sexed. It could be a man and a woman engaging in the act of sodomy. Well, some states did not outlaw that, but outlawed same-sex sodomy. And so these two issues sort of narrate through these laws. But the problem and the underlying function was it was pretty difficult for courts to get access to these laws that were on the books. And the reason for that is individuals were so rarely charged with violation of sodomy laws. Because the overwhelming majority of sex doesn't happen in a place where the state is regularly observing. And so most states didn't actually use the sodomy laws to actually prosecute anyone. There were a number of other laws that could be used if the sex was in a public fashion. But private sex and laws regulating private sex are exceedingly difficult to enforce because it's private. And it's not occurring in a place in which the state is traditionally observers. And so it takes an interesting factual setup to actually get to a point where you can legally question, whether sodomy laws are constitutional or not. And really the first time that the court does this is in Bowers v. Hardwick in 1986. And so here's the factual setup for this case. Hardwick was an adult male and charged with violating Georgia's law against sodomy with another adult in the bedroom of his own home. And so you kind of have to ask the initial question, how did anyone know that Bowers was engaged in sexual activity in his own home? Here is how this ends up getting to this point. An police officer knocked on the front door, and although there was no answer to the door was slightly open, and so he pushed open the door and walked in to see if anyone was home and found Hardwick engaged with sex with another man. And so Hardwick is charged with violating this anti-sodomy statute. Now, why was the officer there? He was attempting to serve a warrant, and therefore the officer was in the access of his job and did come across evidence of violation of an anti-sodomy law, and so arrested said individual, Hardwick, under that law. The local district attorney, however, chose not to prosecute this matter, which means that Hardwick in this case was not formally charged with the crime of criminalizing sodomy. But it still gave Hardwick's standing to question the law, and he did so by bringing suit in federal court with the attempt to have the statute declared unconstitutional. And so the issue in this case is whether the anti-sodomy statutes violates fundamental privacy rights of homosexuals, because the law in question did apply only to some same-sex individuals in the state of Georgia. So the decision in this case is a 5-4 decision that there is no fundamental right to homosexual privacy, and as a result, the law itself is not unconstitutional. According to the majority, all decisions up to this point on the right to privacy had concerned natures that happened within the confines of heterosexual relationships. That is, marriage, family, and childbearing. And homosexual activity does not, in 1986, include those. Accepting the decisions in these cases like Griswold, Roe, and etc., we think it evident that none of the rights announced in those cases bears any resemblance to the claimed constitutional rights of homosexual to engage in acts of sodomy. There is no connection between familial marriage or procreation on one hand and homosexual activity on the other that has been demonstrated before this court. And so just because the past cases, none of them dealt with homosexual behavior, the court was able to carve out an exception to all of those cases for homosexual behavior. And so even though the other cases seem to lead on a direct path that consenting adults in the privacy of their own home can engage in sexual acts, in this case, the majority was not willing to take it that far. And basically, the court says that this issue has traditionally been held by legislatures. Most states ruled that sodomy had been legal, and so until the year 1960, all 50 states criminalized sodomy. 25 still criminalized it when this case took place. So the court isn't wrong in saying that the states had traditionally engaged in this behavior, and so they conclude that against this backdrop, to claim that the right to engage in such conduct is deeply rooted in the nation's history and tradition is at best facetious. So the court was not willing in 1986 to invalidate sodomy laws, which it takes a long time for the court to revisit this issue. Now, Justice Powell concurs, but concurs only in the judgment of the court. So he doesn't concur in the decision. And he argues that he agrees that there's no substantive due process right to cover homosexual behavior. Substantive due process doesn't go that far. He argues, however, that the Eighth Amendment does provide that cruel and unusual punishments are prohibited, and considering the state of Georgia provided a potential penalty of 20 years in jail for sodomy, Powell was strongly encouraged to say that that portion of the law was horribly problematic. For the individuals in dissent, it's a very simple argument they make. Justices Blackmun, Brennan, Marshalls, and Stevens all very easily go, first off, this was private, consensual activity occurring within the confines of an individual's home, an area of traditional privacy rights, and as such, this should be very clearly defined under the fundamental right of privacy, and that one need not extend an argument of substantive due process rights to homosexuals. This is simply very easily confined as sexual activity between consenting adults in the privacy of one's own home, an area which we have acknowledged time and time again is a fundamentally private area, and therefore this law in question is repugnant to that line of precedent. But the majority does not feel that way. Now, I want to revisit Justice Powell, because I think Justice Powell is pretty telling about really where society was in 1986. And this isn't to sort of give deference to Justice Powell, but more or less to give some understanding of the context. He concurs only in the judgment. It's pretty clear based on the records that we have that he was going back and forth in this case a number of times in terms of what side he was ultimately going to vote on. He indicated in conference that he would vote to strike down the law as unconstitutional, but after the opinion was circulated, he changed his mind. So his vote very clearly makes this a 5-4 vote from the law being unconstitutional to the law being constitutional. Now, there's an intervening circumstance here that provides some indication of really how out of touch many members of the court can be, and also the confines of what 1986 looked like. After he retired, which wasn't long after 1986, after he retired, he did what most Supreme Court justices that retired do, is they have a big party, and they invite all their former law clerks back, and they have a shindig. And one of the clerks in question, or one of his clerks who attended, asked him about his decision in Bowers v. Hardwick, and asked him why he made that decision. Basically, he pressed him like, Justice Powell, this is the sort of decision that frankly shocks me because, you have long been a defender of privacy rights, and this seems to just naturally extend into those areas. And Justice Powell went, well, I made the decision in this case because functionally, I don't know any homosexuals. And the clerk was a bit taken aback. The clerk told him very clearly, well, Justice Powell, you very intimately know a homosexual because I'm homosexual. And that decision hurt me in a very systematic way. And Justice Powell had already clearly at this point struggled with how he was going to make his decision during that time. And so in an almost unprecedented move, the next day after his retirement party, Justice Powell gives a public press conference in which he says that the decision in Bowers v. Hardwick was wrongly decided, and that he could do it all over again, he would have voted differently. And it should show really the context of what 1986 was for gay rights in the United States, but also much more systematically, how easily judges can change their minds. Justice Powell in this case went back and forth during the case, and when provided with any form of direct attachment to it, said that he had decided wrongly. And if persuasion really is that easy for judges on the United States Supreme Court, which I truly believe it is, it shows that how much one vote can really sort of set the tone for law over a period of time. Because if Justice Powell had voted in the other way, if he had had that information on the day he ultimately decided the case, we wouldn't wait until 2000 2003 in Lawrence v. Texas to see sodomy laws struck down. And perhaps the trajectory for gay rights in the United States would have started much earlier. And so it's really this one key circumstance that really shapes this area of law going forward. And I think that's interesting to see. And so for me, the more interesting discussion in this case is really Justice Powell, and how this case turns out is a function of his vote, and how much he struggled with that vote should be part of the discussion.